new U.S. immigration rule affecting international students, exchange visitors, and foreign journalists is now facing a federal lawsuit. A coalition of unions and advocacy groups sued the federal government on August 18th, challenging a Department of Homeland Security rule that changes how long certain foreign nationals can remain in the United States without applying for an extension. The rule is scheduled to take effect on September 15, 2026. Under the new system, F and MJ visa holders, including international students and exchange visitors, would generally be admitted for a fixed period of no more than 4 years. That is different from the current system, under which certain students and exchange visitors can be admitted for the duration of their authorized program rather than a fixed maximum period. The rule also affects I-visa holders, which include foreign journalists and other representatives of foreign information media. For journalists, the new admission period would generally be limited to 240 days, while Chinese nationals would face a 90-day limit under the rule. The groups challenging the rule argue that these restrictions could create uncertainty for students whose programs take longer than 4 years, and could discourage international students and scholars from choosing American universities. The News Guild CWA also described the measure as an attack on journalists. The lawsuit was filed in the U.S. District Court for the District of Massachusetts. The Department of Homeland Security, however, has defended the rule and dismissed the lawsuit as performative. DHS says the changes are intended to address fraud and ensure that people receiving student visas genuinely intend to study in the United States. For Indian students, the important point is that the rule has not yet taken effect. The scheduled effective date is September 15th, but the lawsuit could affect how or whether the rule is implemented. So this is not a story about an immediate cancellation of student visas. It is a legal challenge over a major proposed change in how admission periods for certain non-immigrants are determined. The next major development will be whether the court intervenes before September 15th.